And judges. Start with Erica.
Hi, I'm Erica Preston-Roeder. I'm a philosophy professor at Washington.
My name is Kyle Hirsch. I teach philosophy at San Jose State.
My name is Nasim Sayeda. I'm a former debater, and I just love moderating judges and people in that.
Okay. So, for Stanford, this is case number 10. This is not your grandparents' seance. The question is, do people have a right to, stop writing, sorry, I had the question straight. Do people have a right to control the use of their likeness after death? Why or why not? The question is, do people have a right to control the use of their likeness after death? Why or why not? And your timer to confer for 2 minutes begins now. And that's time. Okay, Stanford, you have 10 minutes for your presentation, and your 10 minutes will begin now.
Okay, we'd like to start by thanking the opposing team for coming to have this conversation with us today and the judges for making this possible. The question we received reads, do people have a right to control the use of their likeness after death? Why or why not? And we think the answer to this question is yes, that people after death have the right to control their likeness through a post-mortem right of publicity. This is something that exists right now when it comes to an actor and using their face in, for example, a movie. And we think a very similar thing would happen in the case that we received about dead chatbots, which can simulate a dead loved one and use their face in order to have a conversation with a living relative. And so we believe that the beneficiary of a will should carry on the consent of the dead person after they die and the control of their likeness. So with that being said, I'm going to pass it off to my teammate Natalie to talk about the two types of harms to the dead.
Thank you, Ursula. So now that Ursula has laid out our answer to the question, I'll be talking more specifically about what philosophical lens we'll be taking when we evaluate this situation. So first, we want to think about what harms are associated with the dead. Can the dead truly be harmed? We generally, in the philosophical tradition, don't think of the dead as moral agents, as they can no longer exact their intentions, pursue their own consideration of the good life, and experience pleasure, pain, or consciousness. And so the dead can't be directly harmed. They can't experience emotional or physical harm. However, we do have certain intuitions around the dead that tell us that there might be other harms associated with them. For example, if someone were to spit on my grandmother's grave, I know that she personally wouldn't be emotionally or physically harmed by this action. However, I still would experience some sort of moral outrage that a moral wrong has been done. And in order to guide us on what these harms specifically are, I looked to philosopher David Boonin, who posited a theory of posthumous harm. Posthumous harm is the idea that while the dead cannot experience direct harm, they can experience a harm to their memory or their legacy. And so we believe that that is a salient harm here that is the case when we're looking at someone using the likeness of the dead once they are passed. And so in order to flesh out what a posthumous harm looks like, I can provide an example. So, for example, if someone were to write a revisionist history of MLK's life, aiming to sort of defame him or create some sort of libel, we would think of this as a violation of his posthumous kind of rights. It would be a posthumous harm because it would be violating his legacy and spewing false information about his values. In order to clarify further what posthumous harm can look like, I will pass it on to Mirabai.
Thank you so much, Natalie. So now that we've established these harms and the importance of it, we want to talk specifically about how these posthumous harms could actually happen. And to do that, we'll use the example of grief bots. Grief bots are trained to mimic and impersonate the person that they're trying to be emblematic of as much as possible. So that's things like mimicking their speech patterns, mimicking their quirks whenever possible. And these bots can even have things like the person's likeness. But this could be problematic because while these grief bots are meant to blur the lines between fiction and reality, we also see that these grief bots could then assign false beliefs, values, or even actions to this person. And this is especially dangerous because of how entwined it becomes with the person. We also see that there could be a problem, for instance, if someone explicitly said that they did not wish to have a grief bot made of them after death, but if this actually did happen, because then that would be going directly against their wishes and directly against their ideas of their post-mortem requests. We believe that these are especially risky because when we actually look at grief bots in particular and other such AI chatbots, we cannot control the outcomes due to their black box nature. That means that we cannot ensure the accuracy of these devices, and we cannot properly regulate them. This is also especially concerning because these grief bots are meant to act as if they are in the character of a person. But that means they have to take on the character nuances and the quirks of these individuals. How could they possibly do that when they're trained on such limited data? In the case, for instance, it mentions that these grief bots are trained on the social media posts. But that doesn't capture how someone is perhaps as a parent or after a long meal with a close friend. We want to understand these ideas of posthumous harm and how they can affect people, and we use grief bots to do so. But to continue on this point, I'll pass it back to my teammate, Natalie.
Thank you, Mirabai. So Mirabai just clarified using an example from the case, grief bots, which are a common term in the literature for chatbots or AI models of a dead person who can be created through data submitted by their living relative. This was a good example for why we think that the likeness of the dead should be controlled by someone. And to further clarify what that looks like in the status quo, I will be looking at a specific legal precedent called the post-mortem right of publicity. This is something that already exists in the law. Essentially, it is the idea that the beneficiary named in the will of the deceased has ownership and control over their likeness. So this already helps when we're dealing with issues of the dead's likeness being used in certain ways, such as for commercial purposes. However, we think that this could extend to the other issues listed in the case, specifically this idea that we can create an AI from data about the person who is deceased. We think that the beneficiary in the will is the best person to really exact control over the likeness of the deceased because they are the one who will be best able to interpret the wishes of the deceased. And we think that this is good for there to be a living representative who can control the likeness of the deceased because the dead have no say over what is done with their likeness. We can't obtain consent from them anymore. Of course, if there was a dying wish that they put in their will, you would expect the beneficiary to act on that, even especially if it related to their likeness. However, for all other gray areas, we would really refer to this post-mortem right of publicity, which we think is very morally justified in this case for the reasons that we've stated, mainly that the posthumous harm that can be caused by someone using the likeness of a deceased person can be quite great. Now I'll pass it off to my teammates for some objection.
Thanks, Natalie. So, something that someone who disagrees with our case may object is that there are many cases in which we represent dead people after they pass, and we tend to not give them control in these cases. Some examples might be biographies, textbooks, plays, where while it's not their likeness, you are still talking about the life of a dead person. Another example that may intuitively not seem unethical is a chatbot that recreates George Washington, and it actually is his likeness and it allows people to have a conversation with George Washington. What's the problem there? So I think I'd like to handle these two different cases separately. In the cases of things like biographies and textbooks and plays, the reason why we don't think this post-mortem right of publicity extends is because we think there's something unique to a person's likeness. Rather than a biography which describes a person's life, we think actually representing the face and the speech and the thoughts and values of the person is what puts posthumous harm at risk. Whereas plays and biographies and textbooks, if it's a different actor acting out a person's life or just describing their lives, we don't think that this same value really is at stake. And then in terms of the chatbot of a historical figure like George Washington, one limit we have on our case of this post-mortem right of publicity is that it usually has an expiration date. In different states, I think in California it's like 40 years, and in New York it's 70 years, and we think this makes a lot of sense because after many years we don't think posthumous harm is as likely to occur, and the beneficiary of the will and all the living relatives of the person usually have passed, and so we do think this post-mortem right can dissolve over many years. With that being said, I'll pass it off to Charlotte for one last objection.
Thank you so much, Ursula. So I guess my final objection would just be, having established this kind of like why this broader use is not okay, how about when the use of someone's likeness in the form of like a grief bot aids in the living's ability to process grief? Shouldn't this benefit supersede a dead relative's right to control their likeness after that? Well, to that we say, we reject the very premise that this is a benefit, right? There have been a range of psychological harms that have been much discussed in literature that state how, because of the nature of grief bots and how they mimic the dead in such like an uncanny way and allow for the living to engage in a uniquely reciprocal relationship, that there are these psychological harms that would actually impede the living's ability to process the grief. And so with that, I'd like to pass it off to Adam.
I'll just clarify in addition to Charlotte. So suppose that the grief bots actually were very helpful in helping people overcome their grief after a death. We think that humans who are living have a lot of options to cope with grief, while a dead person has nothing left except their memory. So we think that this harm is even more important because it can't be distributed and so it's protected. And with that, I'll pass it off to Natalie to conclude.
Thank you, Allie. So in conclusion to our case, when we're looking at whether people who have deceased have the right to control the use of their own likeness, we conclude that yes, they do, through the form of the post-mortem right of publicity. Of course, if a dead person has put in their will that they wish certain things to be done with their likeness, that ought to be carried out. But in all other cases where we don't know for sure what the dead would have wished for, we rely on the beneficiary of the will to exact control over the likeness of the deceased and make sure that they're not posthumously harmed through the harming of their memory or through the harming of their legacy. And so in conclusion, thank you very much for your time today. We look forward to engaging with you on this topic further and your response.
Santa Barbara, you have 1 minute to confer. Okay, that's 1 minute. Santa Barbara has 5 minutes to provide a commentary on Stanford education. The commentary begins now.
Thank you guys for an excellent presentation. It's stimulating as ever. So I think we should start with the stance, logically. And I'm wondering, you held pretty strongly that the dead can indeed be harmed, but I thought there were certain certain uses of language in your argument, or even specific examples that you gave, that indicated that maybe it is not the dead that are being harmed, but rather those who are grieving. Natalie, the one thing that you said really piqued my intuition. What I was thinking beforehand, crystallized it really well. You were saying that if someone were to spit on my grandmother's grave, I would experience moral outrage. That was exactly the way I would put it as well. That it seems like, even in this, the way you put it, the posthumous harm, this harm towards one's legacy, towards one's memory, even that, it seems like can be separated from the person themselves, and is something that is actually experienced by the aggrieved, which would mean that it is not harm to the dead. And I'm saying this not only in broad terms, though it matters philosophically, but specifically for its application to the case, which I think my colleague Shereen has been.
Thank you, Henry. So we agree that the harm can be done to the dead, but in the case that the person, while they are still alive, can opt out of this technology or opt in, so they would have complete informed consent about how the company would use their data and how to go about this. How do you think it is an absolute no for everyone, or do you think that in the sense that they have full informed consent, you can mitigate that and the technology will be
Right, so specifically what we're considering very briefly is a sort of opt-in method where even if the person who is, let's say, is in old age and they have disagreement, this will-like situation with their family where both parties understand that once they pass, they can have a grief bond. This nuanced and considered approach in which both the person who is soon to be deceased and the soon to be grieving, would you still hold that this should not be applied? Or is it a categorical, or is it a matter of extent, a nuance?
Yeah, I'm curious about, you lean heavily on the beneficiary of someone's data and likeness to make the best interest for them. You kind of assume that it's a given choice, but in cases where someone may not have a good relationship with their family, but also no clear will, and that likeness passes over, it seems it may not be in the dead's best interest for them to be represented in a poor light, but if that's what the beneficiary prefers, I'm curious how you balance this. And secondly, I'm curious, there was a brief discussion about the living's right to choose how they grieve, and maybe even if it's beneficial to the living, and I wasn't clear on why you are dictating how the living ought to grieve and putting limits on it. I'm curious if you would put limits on, say, psychics or mystics, which may also be exploited.
So I wish I could hear a little bit more about the philosophical reasoning with the AI itself, because I think right now you're looking at it through the lens of what we can foresee in the foreseeable future as being this AI chatbot. But what about when AI develops further? How does your framework account for nuance in the sense of technology, right? And what about accuracy? What if the chatbot is getting things wrong? That has become less permissible, and to what degree? Where is the line here? I want to bring up a hypothetical scenario where, let's say, in the metaverse or something, you have a dead person chatbot that is now able to spend currency from their estate on fungible tokens in the metaverse and functionally act as a character in another universe with its own autonomy in the digital world. Is this okay? To what extent does your philosophy account for AI? Furthermore, what about profit? In the same way that actors can profit from their likeness posthumously, what about profit from the chatbots? Does this go just to the beneficiary? Does it go to the state? And I'm also a bit confused. So if someone is portrayed positively but falsely under your framework, where does that lie? Because it seems like you care about accuracy, but you also care about harm determined by the beneficiary and the family. And then I'm also confused about what if all of the family thinks of harm as one thing, but then the beneficiary thinks of harm as a different thing. There's just a lot of nuance that I'm a bit confused about.
And lastly, you emphasize the importance of the dead's likeness being accurate, but you also say that the dead can be harmed. So in this way, should we prioritize the accuracy of the dead and the portrayal, or should we prioritize the feeling it elicits in the living relatives?
I wish we could give you a summary last week and not. Thank you so much. We look forward to your responses.
Okay, Stanford, you have 1 minute to confer. Time is now. response to commentary, and then 5 minutes to begin the sit-down.
Thank you so much to UC Santa Barbara for that engaging commentary. We'd love to respond to some of the points that you brought up. First, I would like to start at the top of your case, talking about how it's not actually the living harms, but the living who are experiencing moral outrage due to the actions committed regarding the dead. We would argue that, well, actually, we kind of reject this notion through the lens that we're viewing this case with, which is David Goodman's theory of posthumous harm. Our idea here is that the legacy of the dead is not something that is contingent upon the living, right? So a dead person can have a legacy that goes onward, and if that legacy is tarnished, even if no living relative ever knows that it's tarnished, we still think there's something wrong about that. And the reason that David Goonan brings this forth is to have this idea of frustrated desires, right? So the dead have desires for how they are to be viewed after their life ends. And this idea that those desires are frustrated without kind of the dead knowing that they would have been frustrated is how he posits this theory of posthumous harm. And we think that this is the normative reason why we have wills in the first place, is so that the dead can exact their wishes after death and not have them frustrated and experience posthumous harm. So I would argue that even if the living did not witness this occurring, but there was still a harm that took place. However, a second response is that even if you were to say that the harm to the living was the only harm associated with the dead, we would still say that our framework holds, and that it's still good for the living relatives of this person to control their likeness, specifically the beneficiary, who is usually a trusted person to the deceased. So we think that that doesn't necessarily rebut our framework, but rather still allows for this idea of postmortem right of publicity. Next, I'll pass it off to Mirabai.
Thank you so much, Natalie. I wanted to address your second point, which is the question of what if someone wants to actually opt into having pre-plot created after they're dead. And we want to highlight here that we're not telling people how they should create their legacy. Instead, we're simply trying to protect their right to actually create this legacy. So we would say yes, absolutely. If you truly went in, informed about what this pre-plot would do, and still decided that you wanted it, then you would be allowed to do that. We also want to tie this into your next point, which was the idea of what if there was no clear will or if there was a bad beneficiary. And we want to go back to this highlighting of we believe in this person's choice of how they want their legacy to continue. So, for instance, in the case of beneficiary, we do not think it's our responsibility or our right to decide whether or not the beneficiary is actually accurate. We believe that when a person chooses their beneficiary, we have to the dangers of not doing so and actually deciding for this person that their beneficiary is not good enough are a little bit too great for us to contemplate this possibility. Next, I'll pass it on to my teammate, Abby.
Thank you very much. So first, I'm gonna touch on your objection about maybe the living ought to have a right to choose how they grieve. Maybe we shouldn't dictate how people grieve. And to that, we'd say that this liberal conception of having the freedom to do certain things and live a good life is a really important consideration. But I think there's like a saying that says, like, my freedom to extend your fist extends as far as someone else's nose. So we have articulated that posthumous harm is a harm that is real to other people. And so our ability to grieve however we want would extend insofar as we don't create posthumous harm over the dead, towards the dead. And in terms of like having a spectrum of ways to grieve, like going to mediums or psychics, we'd say that most of the time we think that these forms of grieving are perfectly acceptable because they don't use a person's likeness. But if I went to a psychic and they were trying to push an agenda on me about my dead grandfather's beliefs or something, by putting false things into their mouth, then we would probably morally object to that because that counts as posthumous harm as we've articulated in our framework. So that's an extension of our framework to these different scenarios. And with that, I'll pass it on to my next teammate.
Sure. So another one of your objections was that, or really was just this question of who should be able to profit off of the dead's likeness. Should it be the beneficiary or should it be the state? I think we would say that this would vary from case to case based on what the beneficiary decides. So if the beneficiary decides that the company who's creating the AI chatbot that people can talk to is going to be the one to profit, they would be able to, really it's just in the hands of the beneficiary to make this decision. We don't think the government should be enforcing a be-all solution for this. I'll pass it to Georgios.
Yes, and so thank you, Ursula, for addressing your point about profit. The last point that we want to touch on is this idea of AI developing further and potentially having individuals acting in the metaverse who have died, but who have some type of personality that lives on. And what we would say to this is that when an individual dies, we think that their likeness needs to be controlled in some way by someone else, because we recognize that the changing circumstances of our life, as you've mentioned so eloquently with the topic of AI, are evolving so rapidly. And so we need someone who is able to process this new information and exact control over how their likeness develops, even with the future development of AI. So we think that we don't know what may happen in the metaverse, but we would still say that once an individual dies, their likeness, the control over their likeness goes to the beneficiary, and the beneficiary decides, and that's 10.
Okay, judges, you have 1 minute to confer questions. That 1 minute period begins now. Okay, judges ready? Okay, the 10-minute judges Q&A period will begin now.
So we've heard this whole argument about the importance of maintaining a legacy. Kyle and I are friends. I just found out I'm probably going to be for another week. Kyle just had a checkup. He's really healthy. It's been 20 years. We josh around and joke. My legacy, I have determined, and I want my beneficiaries to learn, is to keep mocking, making fun of Kyle, just, sending all sorts of pranks that he's told me that I should stop doing. Just that. That's my legacy. I want that to be my legacy. And I know it's going to bother Kyle. It's going to harass his family and friends. That's my legacy. That's what I really want my beneficiaries to do. Is that
Basically, I think I actually really appreciate this, and I think this is a very interesting question. And I think we might actually go back to what my teammate said, which is that my right to extend my fist goes as far as it hits your nose. And so that would be the similar case here, where we absolutely recognize that perhaps you might want to have this as a legacy. And insofar as it is solely in your own legacy, we would accept that. But when it involves harassing Kyle, then we would say that perhaps this is not as good, nor would we say that this is actually perhaps even more of a praiseworthy action to continue harassing someone you would actually get on.
But I hear the argument where the importance is on legacy. We haven't determined who determines whether, my right as a person who wants to leave a legacy is more important than Kyle feeling whatever he does. We didn't hear that. So why do I really care about how Kyle feels if my feelings are to be respected, my memory and legacy through a beneficiary?
So just to clarify, so you're concerned about whether you're, sorry, I'm going to respond to it and maybe frame it a different way. So we think that maybe these memory rights, these preservation of your legacy rights, we think these are more like a negative conception of rights, whereas you're not allowed to stain these memories. You're not allowed to taint them with false information after someone dies. But maybe they're not necessarily positive rights, where I want to continually renew my memory by forcing someone to continue, not forcing, by asking someone to continue to do something that I did when I was alive. And so it's more like I preserve something so it's not tainted, but I don't necessarily force it to stay continuous action even after I die. Did that seem to frame it in a more sensible way?
Sure. I love when I write out a question and the other team brings it up that they don't answer it, because then I get to ask it. So I really want to know something that you brought up, which is, what if we swap it around and there's a bad person, someone who is an abuser and who has caused harm to their family, and they make their specific legacy positive, they make it good, right? And now it seems like there's a big conflict here of the rights of the deceased and what their legacy they want it to be, even if it doesn't truly represent the truth. And And then there are living family who has to deal with it, who has to like live with that, but as long as they do, right? I don't understand, where's that lie?
We'll take a second here. Thanks.
So if I understand your question correctly, the situation you have at hand is there's someone who is really terrible, they died, and their family decides to just erase all of that and put a very positive spin on their legacy.
No, sorry. It's the person who has died before, they totally agreed to the chatbot. They won it. They're totally, and they made it specifically to represent them as a good person,
Yes.
when in reality they were not.
So they were a bad person and they made a chatbot that
Yes.
portrays them in a very positive light.
And what about their rights in that situation?
The rights of the family members around them.
Wait, so can I help?
Please.
One, you sometimes say that the person who died has a frustrated desire, right? But that's intention. This guy has a desire to be seen as a good guy, even though it's false. Another thing we might think is important in the legacy is accuracy. So you're creating a case where those two are in conflict.
Okay, so now I see the response. So what we would say in this case is that we recognize that the individual can create a chatbot or some other type of representation of themselves that portrays them in a very person. What we do not say is that they also have a right to prevent all their family members or other members from providing a different narrative than the one that they believe about their legacy. And we differentiate between this type of engrossment that exists with a chatbot saying, I am this person, versus someone else saying, from my perspective as a family member, as a spouse, as someone who interacted with this person as a colleague, I found them to be a very terrible person, or someone who displayed very poor ethical quality. We would never say that someone in their legacy can place a gag order on others expressing their own experiences, but we would broadly support this idea that they are willing to express themselves or provide some type of representation of themselves that might not be entirely accurate. And so in that case, it seems that we've erred more so on the side of preserving the person in their way they express themselves, rather than forcing them to be accurate in their expression. And we think this also is very similar to the way expression exists for living people. We do not force everyone to express themselves in an accurate way. We believe that the freedom of expression is more important than individuals being governmentally or otherwise mandated to be accurate in everything they say. But again, we do not suppress the other voices that might exist.
All right, so I understand the claim that there's a kind of harm to the legacy. I understand that you're claiming that the deceased therefore has a right. But I'm wondering, there's a gap there, right? Here's a different ethical framework. You could say there's a harm that might happen to the legacy. So all the survivors have an obligation not to incur that harm. This person over here who died, they don't control it. They don't have some right to control what happens. That's part of what's getting you into trouble over here, all these frustrated desires. I want to control how people will think about me. No, the issue is that you could harm me, and everyone shouldn't, but it's not a right that the deceased holds. You understand the difference? Why a right that the deceased holds? Why claim they control it? Well, we'll take a second.
In response to clarify, I'd like to kind of elaborate on how we're conceptualizing this idea of the dead having particular right. So essentially, when we think of posthumous harm, we're looking at someone whose memory is violated in some way, and usually in an inaccurate way. We generally value accuracy very highly when we're talking about this. And we also look at this very similarly to how we look at wills, right? We think that a dead person has an obligation to exact what should happen to their property, how the things should be distributed, and the immediate beneficiary can exact those wishes. We think about their likeness in the same way. Their likeness is something that's very personal and relevant to them, and something that can very easily be order to warp the way that they were supposed to life. And so we think that the dead have this right to, say what their wishes should be insofar as they're not harming other people, and name a beneficiary who can exact that. And this beneficiary is the one that has control over the likeness. So we think that that is kind of our idea here. We're treating this like wills. A dead person has a right to control things after death, specifically their likeness, because it's so personal to them. Does that kind of answer your question?
I don't know if it does, but I also know it was a hard question, so.
It was 1 minute.
Maybe, I guess something I can say, potentially add on to this response is, maybe there's something unique to likeness that gives the dead a right in this case, rather than just a negative right to other people not interfering. And the reason why is, even if you had a likeness that was, like, quote unquote accurate, I actually kind of question that idea, because any representation of a dead person having a conversation with someone is, I guess, inherently inaccurate, because it's not them actually having a conversation. And so that's why maybe with likeness specifically, we think the only way to protect this right to, and to not suppress your desires is for the likeness, or for the chatbot not to be created at all unless you give consent. But instead, consent in our framework is through this post-mortem right of publicity. So hopefully that was more helpful.
There's only 10 seconds left.
Okay.
So, yeah.
I read the book, it's incredible.
Okay, that concludes the first half of the round. Judges, please record your scores. Okay. I will just say very quickly before I start, I know it's so tempting to want to talk to your teammates during the round. I fully understand that desire. It is very easy to hear the discussions and the murmuring while the teams are actually presenting. So try to keep those as minimal as possible, but I understand the desire and the impetus. But it's remarkable what you can hear, I think, in a lecture room designed to capture and project sound. So just as a warning. Thank you very much. And then also just to clarify, since we're providing the questions, please don't start writing until after the time begins. I know I didn't clarify that earlier on, but yes, writing questions. Okay. So, Santa Barbara, your question comes from case number 3. Oh, yes. Here. Case number 3. Oh, you need more time. Sorry. Very hard. Here, I have. Oh, you got it? Case 3, car calls the cops. Were Alan McShane's rights violated? If so, by whom? Were Alan McShane's rights violated? If so, by whom? Your 2 minutes to confer begins now. And that's time. Okay, Santa Barbara, your 10-minute presentation begins now.
I'd like to thank the opposing team and judges for the opportunity to discuss this important case. And to answer the question, were Allen Exchange rights violated, and if so, by whom? We're inferring that this is referring to privacy rights due to the potentially invasive nature of this safety technology. And we answer that no, Allen Exchange rights were not violated because this safety implementation is meant to protect, not incriminate people. I'll pass on to Paul for the summary.
Thank you, Sam. So, to run over the facts of the case, Mercedes hit a curb and activated its airbags, which with it called the cops and ambulance to help in the event that anyone involved needed medical attention. When the cops arrived, they found a drunk driver and he was punished. This case brings up two major ethical concerns. First, thing of privacy, as we're increasingly subject to surveillance, and secondly, that of self-incrimination, as the vehicle acted as a witness against its own owner. That I'll pass it to Grace for the first argument.
Thanks, David. So we hold that reasonable safety precautions that infringe on an action that is intrinsically valueless with respect to its function are justifiable. So that is, dangerous actions must have some sort of intrinsic value with respect to its function in order to be permissible. So to tie to the case, drunk driving is a dangerous action, yet we hold that it does not have intrinsic value with respect to its function. That is, the inebriated state of the driver does not contribute to the function of driving. And therefore, we hold that all dangerous actions must have some sort of this intrinsic value with respect to its function in order to be justifiable. So to repeat, drunk driving simply does not have this. The inebriated state of the driver does not make you a better driver. And because of this, drunk driving is not a justifiable action. Now, one might say that, well, perhaps drunk driving has some sort of instrumental value. It has good consequences. And I will say this is true. For one, drunk driving may make it so that you don't have to call a rideshare to get home, or you don't have to come back for your car in the future. Well, this is true, but it is not an intrinsic value with respect to its function. That is, it doesn't help the function of driving. Now, I'll touch on this next point, which I want to state that the value of action is important to take into account when determining whether or not it is justifiable. So to make this point clear, I'm going to use two examples. So the first is in the case of punching. So we generally hold that punching is not a permissible action because of the danger it poses to others. Yet you could think of a scenario in which this has some sort of instrumental value, for example, in the case of self-defense. In these cases, we would say punching is justified. Yet in the general sense, it is not because of the danger it poses. Another example is the use of fire. So we approve of the use of fire in terms of cooking, for example, with gas stove. We realize that fire poses a serious danger, yet we accept this because it provides us with this valuable function of cooking. Yet you can picture another scenario in which there's a large bonfire constructed in the middle of a forest. In this case, let's say for one's entertainment only. We would say this action is not justified because of the large danger risk it poses and the fact that it is not outweighed by this instrumental entertainment value. So to conclude, or to apply it to, in this case, drunk driving, we would say that yes, drunk driving may have some sort of consequential or instrumental value, but this is not outweighed, or this is outweighed, by the danger hazard that it poses. And in this way, we hold that the autonomous safety system, which is a reasonable safety precaution that may infringe on the act of drunk driving, is justified. And I'll pass it off to my colleague for the next one.
Thank you so much, Grace. So the government has to balance the safety of its citizens with their privacy. So we hold that the government's primary responsibility is to protect its citizens and ensure their well-being. This means that when citizens are in danger, it is obligatory of law enforcement to take necessary action to protect them. even if this comes at the cost of contravening rights temporarily. A great example that I like to use to think about this is that it is typically always impermissible for law enforcement to enter a private domicile or private property without a warrant or reasonable suspicion of a crime, but in the example of firefighters, it becomes obligatory for them to enter the house in order to reduce harm and protect the citizens if the house is on fire. Going more with this trade-off between rights and with rights and endangering others and harm, we can see with the First Amendment. One has the right to free speech so long as their speech isn't a form of overt harassment to others, it doesn't defame others, etc. This is kind of this trade-off that we're talking about. And this is especially true when one's actions harm themselves or others on public grounds. So when one drives drunk, as we mentioned, with no intrinsic value, they are putting both themselves and others at risk. There's a statistical increase in the likelihood of the car crashing when one drives drunk. A great example to kind of put this analogous to is imagine someone walks through a crowded shopping mall with a bomb strapped to their chest, and the police get tipped off by it, and then the person says, "No, you can't search me. This is my shirt and my bomb attached to my chest," right? They can't say that because they're putting the lives of others at risk, so their rights are temporarily contravened. Specifically, only the right to privacy in that situation, not everybody, of course. Moving forward, we hold that those who disagree with this position maybe have a fundamental misunderstanding of how this works in the case of the security system. So, 99% of the time, the security system mentioned in the case is a dormant safety feature. It is not a security feature. It's only activated at a time which, if found, there is a significant safety hazard to both the driver and anyone else involved, i.e. the airbags going off. Airbags are designed so that typically they only go off in situations when there is a serious safety risk. One can say, oh, he only hit a curb, but it was the intention of this automated system to be aware of a serious safety risk. So one can think of this example through this lens and think that they were a family member of someone in the crash. So remember, this is a safety feature, not a security feature. And if your family member is in a crash and the car is crumpled and their phone is too far away from them to reach and they only have a certain amount of minutes left to live before getting medical attention, right? You would probably want your family member to have access to a feature that automatically alerts authorities so that they can get medical attention, right? Once this system deploys, it's going for a safety concern. It's not a direct connection to incriminating the driver. But once the authorities arrived, they saw that the driver was drunk, and because his actions not only caused this, but they were directly related, it was permissible for his right of privacy to be temporarily contravened in order for the safety of others to be upheld, and that being, you can't drive drunk, right? So because of that, we would say that the vehicle did not act as a witness. It is inherently deter drunk driving when it acts as a safety precaution, which did its job. With that being said, I will pass it off to my colleague to address the objections that may be large in the reasoning of those disagree with our case.
So, Grace, first, don't we allow for various intrinsically valueless actions even when their instrumental value does not exceed their danger? Take high-speed race car driving, for example. The instrumental value of which is entertainment, of course, but which is incredibly dangerous not only to the driver, but to his competitors as well. How would you respond to this?
Right, so high-speed racing is an event in which all the participants consent to what they're doing. So in this way, the lack of intrinsic value with respect to the function and the danger of the event are mitigated by this concept of consent. Yet, in the case of drunk driving, other drivers don't expect nor consent to sharing the road with other drunk drivers. In this way, the lack of intrinsic value with respect to the function and the danger are not mitigated by this concept of consent.
Got it. And secondly, Griffin, you briefly mentioned one's private home in your argument, but let's focus in on this for a second. Isn't your car your private property in the same way as your home? It seems like we wouldn't allow this type of monitoring in the home. So,
right. So this is a good question. It's important to understand the nuance of this case. With vehicles, yes, they are private property. When you were in them, what you were doing is private. They are private actions, but they are operated on public roads. Therefore, any action that takes place, any outcomes, any consequences, negative or positive, could affect those on public roads, innocent people who are not, willingly on your private property as it would be in your house. And it's just different because it's both private and public.
that we briefly addressed drunk driving as an intrinsically valueless action in Grace's first argument, and then Griffin spoke about why we believe that the driver's rights were not violated, as this was primarily a safety precaution, as the feature was intended to be. And then we dealt with a few objections pertaining to each of the two arguments. Thanks a lot. We see the rate of time.
All right. Stanford, you have 1 minute to confer, and your conferral period begins now. And that's time. Okay, Stanford, you have 5 minutes for your commentary and 5 minutes for business time.
Thank you so much for your lovely presentation, and we're excited to engage with you. So to begin with, we think that you guys set up really well that we have no right to drunk drive. But I wonder if this really is charitable to the tension that's articulated in the case. It seems like you even said this in the beginning. The right to privacy is the thing that's really at stake. So it seems like if we have this technology, we are forced to interface with law enforcement more than we might want to. And I wonder if having that implemented, especially if we weren't aware that this was a feature of the car to begin with, is actually justified in the name of safety. And so, for example, I want to say, like, what if what if you have a black individual who has e-call or this technology implemented in their car, the airbags deployed, they didn't know that they could be incriminated, but we know that there's much higher rates of violence against black individuals. We think that this right is actually holds a lot of weight, and we don't know if you would necessarily prioritize public safety over the possible escalation of violence to this one individual. And so we're wondering if you can have some sort of criteria or some way to articulate when you have privacy in tension with public safety, how you would figure that out, not just public safety in tension with drunk driving, because we think privacy is the key right that is at stake in this case. Another thing that we would like to press you on is whether is the private property. So you guys did distinguish that private property is different. Sorry, cars are different from your homes because you're in public spaces. But I do wonder, some people have conceptions philosophically of property being an extension of the self. And we have an amendment, a Fifth Amendment, that says you have a right against self-incrimination. And so if you consider your car to be an extension of yourself, it seems like that's an instance of you incriminating yourself, which we are supposed to be protected against for the sake of due process. So I'm wondering how your case holds up against considerations of property being an extension of the self. And with that, I'll pass it off to Charlotte for the next objection.
Thank you so much, Al. So I'd just like to restate your argument. So in terms of, you have stated, no rights are violated, and therefore this technology should be implemented. And the way in which you justified this was by the instrumental value that this technology would afford, specifically increasing safety on public roads. And I believe in your objection you said any action that takes place on public roads can be regulated. Well, in that case, why wouldn't you implement something like eye tracking technologies in every single car to ensure that no one was even having sleepiness or droopy eyes, to make sure to maximize public safety, or even something like a breathalyzer in every single car to make sure that there was no drunk driving ever. With that, I'd like to pass it off to my teammate.
Thank you so much. So I'd like to extend on Charlotte's point a little bit by discussing one of the points that you brought up. And correct me if I'm wrong, but I believe you said that the value of an action determines whether it's justifiable. Now, let's apply this to the actual drunk driving rather than to the safety system in this case. It sounds like, in this case, we are talking about the good is determined based on the consequence of the action. For instance, punching people is okay if it's in self-defense, but not okay if it's doing some harm to someone. But in this case, since he was driving drunk and didn't cause any harm, he just crashed into a curb, then is that okay then? Was it all right that he drove drunk? We also want to address this in the larger context too, because it seemed like there were two conflicting conclusions that might be drawn from your case. You said that in this case, the safety and
So another objection someone may think is that the reason why Alan McShane's rights were violated was because he didn't know that this technology was in his car. So even if you're correct that in general this technology is good and it would be great if it had this safety mechanism, maybe that's only okay insofar as that citizens are informed and it's transparent that this rule exists. Laws may be justified, but only insofar as citizens know that this law exists. So I wonder if you think that consent plays any role here. And then one final objection, I'd like to talk about really the two competing normative backings you have to your case. You talk about something's value is derived with respect to its function, but then you shift more to a consequential framework of something being harmful only if it poses a danger to others. So I wonder, are you taking a teleological or a consequential based approach here? So with that, we really look forward to hearing your guys' responses.
And that's time. Okay, Santa Barbara, you have 1 minute to confer, and that 1 minute begins now. Santa Barbara, you have 5 minutes to respond to commentary, and your 5 minutes begins now.
Thank you guys for some excellent questions. So there's quite a few disparate questions, so I'll try to deal with as many of them as I can at once. The first one, and they're mostly philosophical, so I'm quite glad of that. The first one is the car is the extension of the self, which to begin treating this, we would say that we would not necessarily concede that this is the case. I mean, on a very basic level, the very first thing that you're taught in DMV training is that your car can be a tool, but it can also be a weapon. It's very clear how it is not intrinsically part of the self. It's something that can be wielded to great use or can be very harmful to yourself and those on the road with you. But even if it were a part of the self, we can pretty easily imagine scenarios in which the self is involved in something that would need a safety intervention, essentially. A microcosm of this could be something, and it's not entirely analogous here, but I think it gets at something important, is two kids, for example, running into one another in the middle school playground. We think that it's to some extent analogous, because the principle, for example, would be right for him to intervene in that case, since it is purely a safety precaution, but of course it does not have the element of drunk driving, unless middle school kids are getting drunk. Now, to the question of the breathalyzer in specific, a really interesting one was to track your eyes, whether they get droopy and things of that nature. We think that these should be implemented within reason, and I think that there is a key distinction there. That this is set off only when something indicates that you have gotten into a significant car crash. How well the technology is functioning, that's a separate question that has merit, but it's not 24/7, it's not omnipresent, it's reacting to a very specific thing. This is analogous to briefly mention the TSA case. For example, it is possible that 320 million US citizens, it's possible that one of any of those might be smart enough to sneak something through TSA and blow a plane, but this doesn't mean that we should put everyone on the terror watch list, right? So the breathalyzer should only be for those who have had DUI checklists, such as the terror list, for example, should be on people who have visited Al-Qaeda websites and not every American citizen. Now, for a really interesting and pertinent philosophical question, that of is this teleological or is it consequential? We think that that's not necessarily key to what we think should happen in the case of whether it should be implemented or not, but it's nonetheless important just on philosophical grounds. We think that it errs on the side, it leans on the side of the teleological. We think that that's the more important consideration, that the end, the telos in Greek of the use of this technology is as a safety precaution, and we distinguish that from what happened in the case of him getting indicted for drunk driving.
Yeah, and to just kind of continue off the same point that Henry was just talking about, think about our stance is mostly theological, and if you're getting confused about, okay, well, we said consequentialism, I think the best way to think about it is we said in my argument that the government's primary duty, theological, is to protect its citizens. The way that it determines the safety of its citizens and protects them adequately is based on indications given by consequences. The act, that's just merely an indicator. That's a prerequisite for the duty to take place, right? Moving forward, I think the biggest concern that you guys had with our case was kind of this weighing between rights and then safety, right? How do we balance these? What is the exact mechanism? And I'm really glad that I can actually expand on this because I think this is probably the most important fundamental part of our case. And I think the best way to think about it is that in our framework, everyone has their rights, right? And only when there's an indication of a safety concern and the government feels like they need to take action to mitigate that safety concern, can rights be temporarily contravened, and only specifically and contextually in the point, in the context of the situation. So with the example you brought up of maybe racial biases with policing, we would say obviously it's immoral for anything more than this, for the airbags going off to be a call to the police that someone was injured. Then they respond, they check out the crash, and they deal with it as needed. And in the context of it being a safety issue. And you can once again think about it, that if this person's family members knew that this was the case, they would want law enforcement to have a mechanism by which they can save his life if needed. So moving forward a bit more, it is the safety concern that's a prerequisite to law enforcement in this case. And so we don't think breathalyzers would be justified because once again, all these people have their rights, and we don't think they should lose their right to privacy as soon as they get in a car because something bad could happen, but there's no indicative safety concern, so there's no law privacy.
Thank you guys.
Okay, judges, you have 1 minute to confer your questions, and 1 minute to begin the count. All right, the 10-minute Q&A period begins now.
I want to pick up kind of where we left off with the breathalyzers. Everyone has rights, but they don't have rights to do certain things. But those rights, I thought the first argument was that when you engage in something like drunk driving, you have waived your rights at that point, right? I thought that was part of the argument, was that there was something special about these cases where someone's engaging in a dangerous action that doesn't have any intrinsic function. So it seems like if that's true, I've already waived my right when I get behind the wheel drunk, and the breathalyzer seems totally justified on your argument. So show me how, maybe I've misunderstood the pieces, but help me understand.
Yeah, so I think we try to get away from the language of waiving your rights or losing your rights. It's more so that when safety risk is indicated, rights can be temporarily contravened by law enforcement. And we understand the point about breathalyzers maybe being indicative, and once it's already in there, but you haven't waived your right if you haven't. It would not. The vast majority of the time, when someone enters a car, they are not drunk. So we think that because of this, we would not call this a significant safety concern. It's the average citizen stepping into the car. The percent chance that they're drunk and are going to crash, we would not deem it significant.
think I'm concerned that if you go that direct, like, if there's a right to privacy, and if it's in place even for the drunk driver, then why do we need the whole first argument, right? And if on the other hand, if we need the first argument to demonstrate that the drunk driver doesn't even have a right to privacy anymore in virtue of what they've done, then why isn't the drunk driver who just sits down in the car already have no rights and can do whatever we want?
It was less about waiving of rights and more of the precautions that infringe on these rights are okay. So we're not saying they're given up, but we're saying infringement on rights are okay.
And that is after there's been a case such as the airbags deploying and safety measures being called.
I think a really good way to illustrate this is, so in the firefighter example I gave, right, where the right to privacy, the firefighters can contravene. In that case, if they're running through the house trying to save someone and they see a pile of drugs, right, it would be illegal for them to use that against them in court, right, on the precedent that there was no indication they couldn't enter the house, right, they entered their house on a different reason. But he waived his right to privacy when he was drunk, so then when he pulled over for a safety concern, he can get in trouble for being drunk.
I get exactly that. Why did you spend all of this time on the philosophy of privacy as it relates to drunk driving, when it seems like the key term is actually the safety precaution? And indeed it is. We would say that it is the safety precaution that set us off in the first place. We thought that it was really important, and because obviously you don't know exactly what the question would be, we thought that it would be really important to set off the philosophy that is behind privacy as it relates to what we think is an intrinsically valueless act in drunk driving in the first place. But we think that what set off this intervention that we say is not a violation of his rights is the safety precaution thing in the first place. And I think it's not directly related, but you can, or one cannot directly infer this from our case, but it was still important to bring up the philosophy of privacy relating to drunk driving because of the breathalyzer question. That set us up, for example, of when should this be implemented? Should this be in all cars? And then obviously with the objection that we had, there should only be the case when a reason has been given that the safety measure would be warranted.
Okay, I understand why you said no, but I was so sad because I felt like half the question was just left behind. And I want to go deeper into that. And again, I 80% understand your reason for the rights situation. So I want to think of it this way. Can you give me maybe another counterexample? Just create one right now of how is it possible that if his rights were violated, who? I care about the rest. Just who is that? Come up with a new one for me.
Right.
Please.
We would say that the key thing that our stance as it relates to this relies on is the safety precaution and there being a proper reason for it. So the best example that I can think of is not one relating directly to driving or in the vehicle, but rather something like arbitrary checks by, let's say a government that has a minority ethnicity that it thinks is in, for example, can just have this suspicion of this paranoia that it might incite a rebellion. And it just simply goes into homes because it thinks it's hiding caches of weapons in there, where it seems like there is no, all analysis of the situation would indicate that no such thing is happening. So the key thing, although it's not exactly with the implications of drunk driving and whatnot, is that for the privacy to be violated, there must be a genuine safety measure. That's what you must be instituting. And you might say, okay, where does this lie in the middle? But I think that in this case, it was rather that an accident had happened and
So
something.
I just was ripping. It's the concept of safety, or is it a government
Right, for the whom question, I should make it a bit clearer, I thought it would be on the part of the government in most cases, at least as is relevant to this. I'm sure you could find specific ones where you know.
Yeah, the whole case, like, our stance rests on this, think of it just like a scale where you're balancing the safety and privacy of citizens, and the mechanism by which that's weighed, which gets more priority, that is the government. So if that goes off the scale, and it's, you know, think of this as one side tipping over, if the government is what's holding those weights, so that's the mechanism, it would be the government's side. Thank you.
We have about 3 minutes.
So, kind of the same concept of, drunk driving's not right. Driving really fast, 150 miles an hour on a freeway is not also right. So why does the government not just put throttlers, like speed throttlers? Why do we need them for cars being sold in the suburban areas? Like, I can argue for safety there as well.
Right, so I think this would be a matter of extent and not a categorical one. I wish that, I think it leans more on, this is a pragmatic concern rather than an ethical, there's an ethical basis obviously, but I think the distinction might be critical. So for example, my car, if the speed limit is 70, when it gets to 71, there's a red flashing sign. We think that is not completely permissible and is useful. But when I reach 71 miles per hour, it has an intervention that would be analogous to the one in this case. We think that would be a violation of privacy. Because the scale is not a perfect analogy, but I think it's a helpful one here. So I think there is some point at which you are endangering, because the road is public, not in the sense of the government owning it, but public in the sense that you share it and the safety of it with your fellow drivers. At some point that you are endangering them and you are speeding beyond any reason, for example, to keep up traffic or to go to the maternity ward because that would, right, so there are reasonable distinctions. It seems like you might have followed.
Minute and a half, minute and 20 seconds.
So, you're saying that it's not categorical, but at the same time, the person who drives drunk, knowing that they are doing something that they might risk the lives of others. I'm also, I'm a speed demon. I want to be driving like 120 miles an hour and working expressway. So the idea there, why my autonomy is somewhat respected as the person that I am.
Right. In that specific case, we think that those would fit into the same category at 120 miles per hour. It does not seem like there would be any case in a highway agreement that you would be able to drive at speed race.
I also want to add that throttler seems to be more invasive versus safety, the autonomous safety measure isn't. So you can imagine a situation where, far-fetched, but imagine there's, in light of our recent weather issues, a tsunami on the pier, and you need to really drive fast to get away from that. If the throttler would prevent you from doing so, the safety system would not do that. It alerts the authorities, but it does not stop you from doing anything in that moment.
And it seems like the analogous intervention here would not be the throttler, but rather being pulled over by the police, which is exactly what happened in this case. It was a police intervention. So we think that there is an analogous aspect in the comparison in the intervention itself.
Well done, both teams. Judges, please take a moment to calculate your scores. Also calculate your scores knowing that it was very late and you may be tired. So double.
I'll do it again. I'll do it again.
you are ready, or? Everyone ready? Okay, we'll start with Erica.
All right, don't read anything into the specific numbers, it's a grade really harsh in the finals round, but I gave Stanford 43.5, I gave UCSB 41.
I gave Stanford 49 and Santa Barbara 46.
I have a tie. It's 45 for both.
Congratulations to both teams. Please rest up. Get something to eat. And you're all
Flores.
Safe
Let's make it down to ground level.